So criminal defense attorney and former prosecutor Philip Holloway with us now, and he's been watching this trial closely as well. So good to have you with us.
My pleasure.
You know, we know that the defense is trying to make a case here that the evidence may have been mishandled or compromised in some way. Do you see that working so far?
Anytime there's a trial, Christy, where, forensics is involved, what happened at the scene of the crime is going to be very important, and if police don't do their job correctly, it can create fodder for cross-examination, which is what we've seen here so far, and that actually can lead to reasonable doubt in the minds of some jurors. That being said, in this particular case, the state is traveling under a theory known as joint venture liability. Essentially, they don't have to show exactly what happened. They don't even have to show who pulled the trigger. The judge, in a pretrial ruling, said the evidence is sufficient to show that at least one of those three men pulled the trigger.
Okay.
And that under the circumstances, it appears more likely than not that Aaron Hernandez is the one who was responsible, at least for being the ringleader and planning it. And all they have to show is that he knew in advance, with premeditation and deliberation, that one of the three had intended to kill Odin Lloyd. And if they can prove that beyond a reasonable doubt, they will convict him.
Wow. Well, let's listen to a crime scene investigator here who actually took pictures at the scene.
Philip Holloway, criminal defense attorney. So nice to have you here, Philip.
Thanks,
let me ask you the following question. What do you think, in examining the evidence and looking at the crime scene, the things they found, whether it be the marijuana blunt, whether it be the baseball hat, whether it be the tire tracks or the footprints, all told, what's the most damning piece of evidence there and why, Philip?
Well, Joey, you certainly gave me a lot to pick from, and the prosecutors got a lot to pick from as well. In this particular case, Joey, the defendant, Mr. Hernandez, made some statements that, according to a pretrial court ruling, is described as statements that indicated that he had some knowledge of guilt or culpability in the case, inconsistent statements, statements that may or may not be exactly 100% true. So, as we always say to people, what you say can get you in lots of trouble. And in this particular case, it looks like his statements may be what really gets it done in this case for the prosecution.
Okay, so Philip, when you look at it in full, based on what we know as of this point, who do you think is winning this case thus far, and why?
Well, this is a circumstantial evidence case, and lots of times, Christy, circumstantial evidence cases are really stronger than those with direct evidence, if you can believe it. Well, juries, what they're going to do is they're going to look at the totality of the circumstances, and they're going to say, look, there's no way that he went at 3 o'clock in the morning or 2 o'clock in the morning to pick this guy up to go to a club somewhere. That does not defy what a rational person would do under the circumstances. And where he was shot was only 3 minutes or so away from his home. So you've got him driving the vehicle to the crime scene, driving it from the crime scene. There's evidence that places him at the crime scene. And there's, of course, the statements that I just mentioned that indicate at least some knowledge of his own criminal culpability in this case, according to the prosecutor's theory anyway. And as I said, under the law that applies to this case, joint venture criminal liability, the prosecution does not have to prove that he pulled the trigger, merely that he participated in some meaningful way.
Philip, they don't have to prove that, but what they want to know, that is the jury, is why. So in the absence of a motive, you have Aaron Hernandez. What a beautiful home, beautiful fiance, beautiful little daughter. Why would he do this? What do you think the lack of a motive, or at least a reasonable motive, is going to do with regard to the jury deliberating and finding him guilty?
Well, Joey, you hit the nail on the head. If there's going to be reasonable doubt in this case, it's going to be motive. We really don't know and haven't heard anything about motive. And, of course, we all know that motive is not an essential element of the crime, but that is the kind of thing that juries like to hang their hat on. When they put it all together and they're back in the jury room, if they just can't quite get their heads wrapped around why he would do this, that in and of itself can amount to reasonable doubt. Yes, absolutely.
Sure.
And that's what they're going to be evaluating. Philip Holloway, criminal defense attorney, former prosecutor. Thanks so much.
Thank you,
Great
Joey.
to have you here, Phil. Thank you. All right, so when we come back.